Good morning.
Good morning.
I see that it is online. Will you call the matter?
And it's a civil trial matter appearing before Honorable Justice Suwendo. Case number it's 42728 of 2010. The parties are Living Hands Pty Limited versus Old Mutual Unit Trust Managers.
Yes, thank you. Thank you. Mr. Epson.
Are you able to hear me, my lady?
I beg your pardon?
I was asking whether you're able to hear me, but it seems you can.
Perfectly, thank you.
Lady, we've made some progress since yesterday. Can I first address the position with Mr. Papadakis? He is standing available right now to give evidence, and we will call him. We proposed yesterday that the witness statement.
Before you proceed, I think something is happening with your microphone. If you can correct it, there's a cracking sound that's coming through. And also, I just need you to get...
Sound here. Can I just have a moment?
Yes. Sevilla, please ensure that proceedings are being recorded, because it doesn't reflect so on my side.
I am trying to sort that out, Judge.
Let's just allow for the recording. Are you making any headway? I'm going to adjourn for 5 minutes.
It is recording now, Judge. We can start, Judge.
Right, yes. So we're now on record. Thank you. Mr. Epson, make sure you mute Sevilla.
Thank you, my lady. We've made some progress since yesterday, which will assist in curtailing the duration of the trial. The position is, we inquired from the defendants whether they would be agreeable to a witness statement of Mr. Papadakis. Then it will stand as his evidence in chief, and they can cross-examine him. The response is, and can record it, the response from Weber Wenzel is this: They say it would be acceptable for Mr. Papadakis to confirm the contents of his witness statement and that this stand as his evidence in chief, together with such further evidence as your counsel might wish him to give. This applies also to the annexures to his statement. As regards the weight to be attached to his evidence, including such portions of it as are hearsay, we propose that this be left for argument at the end of the case, insofar as anything is thought to turn on this. Our lead counsel intends to cross-examine Mr. Papadakis. Now, we had given a witness statement to the defendants in December of 2020. I'll come to it in a moment. We have made some minor amendments to that, which we sent to Weber Wenzel yesterday. And we also changed the annexure references, which was 1, 2, and 3. We changed it to the case lines reference numbers. So that statement, which Weber Wenzel is happy for us to hand in on the basis I've just mentioned, is now at case line 01833 to 018104. And the portions which we added in are in red. So 01833 to 104. So, milady, Mr. Bester is going to lead the evidence of Mr. Papadakis on that basis. But can I tell you what impact this has? At 004331, on the 4th of December 2020, we furnished a further request for admissions and inquiries. And at 004340, at paragraph 17, we said and asked the following. We said the defendant is referred to the statement by George Nicholas Papadakis, served simultaneously herewith, including the annexures thereto, and the bundles referred to by him being 1, the final report under Section 3 of Inspection of Financial Institutions Act into the affairs of FAM, 2, the set of curators' reports, and 3, the transcripts of interrogations by the curators. 17.1, the defendant is invited to interview Mr. Papadakis in the presence of the plaintiff's legal representatives to clarify or challenge aspects of his statement. 17.2, the defendant is further invited to admit the contents of Mr. Papadakis' statement or identify which statements therein are disputes and the basis of such challenge. 17.3, I'm at 004341. In parallel therewith, the defendant is requested to admit the allegations contained in paragraphs 81 to 86.9 and 89 to 97 of the plaintiff's particulars of claim. In the event of the defendant refusing to make these admissions, and with reference to the defendant's plea to these paragraphs stipulating that it has no knowledge of these allegations, the defendant is requested 1, to stipulate the basis upon which it persists with its refusal to admit these allegations, and 2, identify the material fact that it has obtained since it delivered its plea upon which it contends that the allegation should not be admitted. The response to that, milady, was on the 23rd of December 2020 in a letter. It's a short letter. Weber Wenzel wrote saying, we acknowledge receipt of your letter dated 4 December. That was the letter attaching this request. We do not at this stage intend to deal with the proposal to respond to the plaintiff's request for admissions and inquiries, and our election to do so should not in any way be construed as an admission thereof. Hereby confirming that our client's legal team is available for a further pre-trial conference. We propose that the conduct all outstanding pre-trial process and procedures be discussed at this conference. So the point we make is this. We're satisfied with the response, and Mr. Papadakis' evidence will now be led. But we anticipated that Mr. Papadakis' evidence would take 2 to 3 days. To this extent, we arranged for him to be where he is now at attorney's offices in Cyprus, and we arranged it for a period of 3 days at expense. So that's where he is now. So, lady, the reason I tell you all of this is because we didn't anticipate that our other witnesses would be needed at least until the end of this week or early next week. But we have arranged, we think Mr. Papadakis won't be very long. We've arranged for Mrs. Atchison, who's our next witness. We got hold of her this morning, and she will come through, and she'll be available to testify from 11:30 onwards, or a little later if we're not finished with Mr. Papadakis. But if we finish with Miss Atchison, we won't have another witness today, because our next witness is in Cape Town, and we're busy flying him up now from Cape Town. We told him it'd only be needed next week. We think, milady, on this basis, we will have 3 more witnesses. Mr. De Jong, who's going to come up from Cape Town, he'll testify tomorrow. And Mr. Milan, and then Mr. Edwards. And we think that on that basis, we may finish Mr. Anderson, sorry, not Edwards, Mr. Anderson. And we think on that basis, we may finish our evidence this week by Thursday. So although we have to stand down, it seems that in any event, by discussion, we're managing to curtail the process. There is one further aspect, and that is that we also took our request for admissions, which was discussed yesterday. We highlighted in yellow those portions which we've asked Weber Wenzel to deal with, to say what's in dispute or what's not in dispute. And the answer they've given is this. They say, it seems to us that a fair amount of what has been highlighted in yellow in the schedule and next to your email and reply is dealt with by Mr. Papadakis in his witness statement. The issues that have been highlighted are many, though, and we shall be unable to revert to you concerning them this evening, which was obviously yesterday. As you will appreciate, much of what has been alleged by your clients is not within our client's knowledge, as the plea records. For us to take all these issues out of dispute requires a decision to be made that the allegations are irrelevant. But since your client considered them sufficiently relevant to make those allegations, our client is placed at risk by simply taking them out of dispute. We shall nevertheless endeavour to respond on at least some of these issues in the course of tomorrow, which of course is now today. That is not, however, a reason to hold up the proceedings, and since Mr. Papadakis' evidence is unlikely in the circumstance to be very lengthy, we'd ask that you have your next witness available after him. So we've done that. Ms. Atchison will be available, and in fact, if we finish early, then we've still got an opportunity to deal with these other issues to see what can still be taken out of the way. So I just wanted to update you on that, and unless there's anything else, my lady, Mr. Bester will now lead Mr. Papadakis.
May I just
check in with Mr. Bam?
Yes, thank you, my lady. My lady, just a couple of things. The first thing is that whichever way one looked at it, Mr. Papadakis was going to have to be available. How long the plaintiffs thought he would be was a question of their estimate. They knew their statement. We knew the statement. But he was certainly going to have to be sworn in as a witness. And once there was a written witness statement, that certainly facilitated the leading of his evidence and the cross-examination. The estimate at the outset of 3 days just seems to me, having regard to the issues he canvassed, to have been an overly generous estimate. There was no way he was ever going to be here for 3 days. But we don't take issue with what my learned friend has said. These are matters that run during the course of the trial. Mr. Papadakis is here. He's not going to be a long time, I can tell you that. In relation to the remaining witnesses, can I say this to your ladyship? First of all, my learned friend is probably unaware because it's just gone off. We have now responded to a list of admissions that further narrow certain things down. Of course, in those lists of admissions, there are also the standard admissions asked, which basically would say, well, do you admit that our case against you is a good one? Of course, we're never going to make those admissions. And when one puts together a list of admissions reasonably, you don't expect to get answers on those. In relation to the remaining witnesses, can I say to your ladyship that we don't think it's going to take long. We don't think the witnesses are going to take long. It may well be that having regard to the fact that other than for Mr. Papadakis, there are no witness statements. So what we hear for the first time. We may need to stand down for a short period of time. And that's not standing down for the sake of standing down. That's standing down so that we can properly consider the extent of the cross-examination, if any, and that saves a lot of time. We think even if we were to lead witnesses, we think we may well be in a position by the end of next week or early the following week. When I say early the following week, by Monday or Tuesday. And that would take into account any desire to stand the matter down so that heads are given to you. That this matter could be ready for argument, maybe. So I'm projecting that just so that everybody can adjust their time. So where we stand at the moment is that we have no difficulty if Mr. Papadakis is put in, if he's asked to confirm his witness statement, and that has to be done, of course, without going through it. I'm not going to be a long time with him, and we'll take it from there.
Thank you, Mr. Fan. I've noted and your views, both of your views. And I must say I expect some appreciation for, taking the matters through and to try and curtail the proceedings. So let's see how we progress. Can
I just say one final thing, my lady?
Yes.
Of course, you'll know that the statement of Mr. Papadakis has just been loaded. I worked on the statement that we had previously. In the course of my cross-examination, when I make references, I'm going to make reference to the original document number, which is not difficult to pick up on Caseline. But I've got my second screen open, so if there's a minor delay as I just scroll through, your ladyship will excuse me. But I can assure your ladyship that I'm going to go through it as expeditiously as I can.
Thank you. I've also just had some problems with Caseline, but I think we can still proceed. Mr. Epstein, you can call the witness.
Thank you, Mr. Vesta is going to lead Mr. Papadakis.
Yes, Mr. Vesta. Yes. Mr. Papadakis,
Lady, apologies. Lady, allow us a second just to get rid of the second noise.
Are judges allowed to fine counsel for things like this on the second day?
Milady, I suppose there should be some rules for the new era around these things. My apologies. It is the microphone on Mr. Epstein's device that interfered.
I think that's the first fine, my lady.
Well, I mean, I give indulgences on day one, but day two, there should be some sort of fine.
Thank you, milady. It seems that it's now been resolved by the team.
Thank you. So you want to call the witness, Mr. Papadakis?
Thank you, milady. The plaintiff's call Mr. George Papadakis.
Mr. Papadakis, will you spell your name for the record?
George, surname Papadakis.
Do you have any objection in taking the prescribed oath?
No.
Will you swear that the evidence you're about to give is the truth, nothing but the truth? Please lift up your right hand and say, "So help me God."
So help me God.
Yes. Thank you, Mr. Bester. That's your witness.
Thank you, milady. Mr. Papadakis, do you have an attorney with you in the room?
I do.
Thank you. Can I ask you to please allow her to be on screen?
Yes.
Thank you. Morning. Am I speaking to Ms. Taufa?
Yes.
Good morning. Can you please, for the record, just state your name? And spell
Yeah.
it for the record as well.
My name is Kyriaki Tofa, name Kyriaki, and surname Tofa.
Thank you. And could you please tell the court what your professional affiliation is in Cyprus?
Yeah, my lady, I'm a certified attorney of the Cyprus Bar Association.
Thank you. And with which firm are you?
I work for the law firm Kalis & Kalis LLC with the address Andreas Abramidis Street, number 9, Pelekanos Building 32, postcode 2024 in Nicosia, Cyprus, which is from where the witness will give evidence.
Thank you. Are you able to confirm that you and your firm are independent from Mr. Papadakis and that there's no conflict of interest?
Yes, I confirm.
Thank you. Have you seen the witness protocol that applies to this matter?
Yes, I've seen it.
Can you confirm that it is being adhered to and will be adhered to during Mr. Papadakis' evidence?
Yes, I confirm.
Thank you. If you could hand back to Mr. Papadakis.
Yes, thank you.
Mr. Papadakis, can I similarly make sure that you have read the witness protocol?
I have.
You confirm that you will abide by that protocol?
I confirm.
Thank you. Can I also make sure that you have access to the Case Lines court file platform?
I have logged on, yes.
Thank you. So Mr. van der Walt will take you to documents on Case Line. So if you can just follow the presenter as soon as he starts presenting, which I am informed is done. So you could just...
Yes, I've logged on to follow presenter.
Thank you very much. Can I then ask you to go to 018-33?
Yes, I'm there.
This document bears the heading Witness Statement of George Nicholas Papadakis. Are you familiar with this document?
I am.
There are some red amendments. The first one, just for illustrative purposes, appears in paragraph 1 on page -34. You see that?
I see that.
Can you just explain to a lady what text in red in this statement signify?
My lady, the court order appointing, the initial court order appointing myself as a co-curator, yes.
My apologies, let me clarify my question. I don't want you to go into the details of what is in paragraph 1. I simply want you to explain to ladyship why some text is in red.
It's in there to signify that it's the 3 companies and their businesses that were placed under curatorship.
The red text, was that in the original statement that we provided to the defendants?
No, it wasn't.
So do you confirm that the red text had been added for purposes of this hearing after your original statement had been given to the defendant?
Correct.
Thank you. Now, this statement with the amendments identified in red, are you able to confirm the contents of this statement as your evidence on oath in this court?
I can confirm it.
And do you?
I do confirm it, subject to this minor error I picked up last night, which I went. I think we will get to it when it's in red.
So it is an item in red?
Yes, it is. It should be an item in red, and it's a minor.
Do you want to tell us what it is about so that we can try and find it and deal with that?
I think we, in reference to Professor Latergan, we refer to him as the stepfather of Mr. Brown. He's in fact the father-in-law of Mr. Brown.
Father-in-law.
Yeah.
Thank you. So that would be paragraph 64.2 at the bottom of page 1018-75, running over to -76.
Correct.
So the word stepfather there should read father-in-law.
That's correct.
Thank you. So other than that correction, are you satisfied with the contents of this statement?
I am satisfied.
Thank you. The lady, you are aware of the arrangement simply to ensure that we follow what Mr. Papadakis' evidence is about, and obviously also just to simply perhaps prime him in some way for cross-examinations, so that it doesn't happen immediately. I intend to simply take Mr. Papadakis through the structure, a few items, and highlight a few items, and also one or two of the major documents that are referenced, because Milady will learn that although this statement is not that long, some of the documents add some bulk to it, particularly the one report that we will specifically refer to. Mr. Papadakis, can I ask you then to return to the first page at -33?
I'm there.
And we just want to look at the structure of your statement so that everyone can follow. And we will briefly just pause at each one of those sections. So can I ask you just then to go to the first section, curatorship. And I want to direct your attention to paragraph 4. And there you refer to a report in terms of the Inspection of Financial Institutions Act. I want to briefly refer you to that report, which reference is given at the end, so I ask that we turn to 015-1. Can you briefly explain to your ladyship what role this report, because we understand from your statement that this report led to the application for the appointment of the curators and thus your appointment. But what role, if any, did this report play in your activities as curator?
Milady, this report essentially served as a basis for us to identify specific lines of inquiry and investigation that we should pursue once we went in as curators. So that there wouldn't be a point of essentially having to reinvent the wheel, and we had a basis upon which we could start investigations and recoveries of assets.
Thank you. Can I ask you to go to 015-12? There you have the heading summary of findings in this report.
Correct.
I'm not going to ask you to in detail go through all of them. I want you to just briefly pause at paragraph 4. The bottom of that page. And you'll see there it speaks of funds received from clients. My question to you is, once you had been appointed and you had looked into the affairs of the Fidentia companies, did you draw any conclusions around this preliminary finding in this report?
Yes, we did.
And in a nutshell, what were your conclusions?
Our conclusions were that these findings of the inspectors were corroborated by and confirmed by the further work that we did.
So does that hold true for all of the findings in this?
Barring the quantification of the loss, the 689 million referred to by the inspectors, that obviously we didn't find the same figure.
Did you find a higher or a lower figure?
A higher figure.
Thank you. Then can I ask you, to go to the recommendations, which you will find at 015-56. And you'll see there the paragraphs 189 and 190. They've also been quoted in paragraph 5 of your statement, starting at the bottom of 018-35, but we can stay where we are for the moment. Now, those recommendations, we understand, then led to the application for the appointment of the curators. Would that be a correct understanding?
I would agree with that.
Can I then ask you to return to your statement at 018-36. And then specifically paragraph 6. There you've identified the 2 court orders, 2 in the sense that there was a provisional appointment and then a confirmation of that. Is that correct?
That's correct.
Thank you. I want to just direct attention to one aspect at this stage. In terms of the final order, what arrangements were made with respect to payment of monies whilst the curatorship is ongoing to the beneficiaries or investors of monies?
The provisional order, my lady, according to our understanding, allowed us to make distribution to pension beneficiaries, which in the context of the investor profile of Fidentia was restricted to the beneficiaries of the Living Hands Umbrella Trust, or the beneficiaries of the source funds to the Living Hands Umbrella Trust, and not any other investors. That was in terms of the first order. And the second order allowed us to start disposing of assets for the purposes of distributing to the 4 investors, being the other 3 investors other than Living Hands Umbrella Trust.
Thank you. Now, can I ask you then to turn briefly to the second part, B, taking control of the affairs. That starts at -44. And perhaps you could just highlight then paragraph 20 to the ladyship what your primary functions and involvement was as curator.
So being a qualified chartered accountant, my lady, I was responsible for the accounting side of the curatorship, which included the accounting aspects, compiling under my supervision the accounting records, supervising the forensic accounting investigations, assuming responsibility to manage the different companies and the properties, eventually dealing with the staff, the IT systems, liaising with the investors and different creditors. And I would authorize the monthly stipend payments to the beneficiaries of the Living Hands Umbrella Trust, and ad hoc payments. So that sort of was my role, and legal aspects were resided under initially Mr. Diwala and later Mr. Levine.
Thank you. I then ask you to go to item D, an overview of the conduct of the Fidentia Group, which commences at -69. Now, you are identifying the funds that were paid by the defendant, paragraph 49, certain amount, and then you explain that there were interrogations, and then in paragraph 51, you refer to a detailed cash flow analysis. Can you just expand briefly what was the purpose of that cash flow analysis?
So the purpose, my lady, was obviously the initial, right up front, was to identify, and as we were directed by the court order, to identify the profile of the investors, how much money they'd invested with Fidentia Asset Management, and then ultimately who were the beneficiaries of the invested funds. In other words, how were they invested? Were they invested, and who derived a benefit from them? And that was the purpose of compiling the detailed cash flow analysis, so that we can identify where the money actually went to.
Thank you. Can I briefly return to paragraph 49? We see there that the monies that was paid by the defendant to the Living Hands Standard Bank account was paid over the period 22 October 2004 to 10 November 2004. So that's the full amount of the 1.1 odd billion rand.
That's correct.
And then, can I ask you to go to paragraph 53? There you say, essentially all of the funds were paid into bank accounts held by Fidentia owned and controlled entities over the period 21 October 2004 to 11 November 2004, and a later payment in June 2005.
That's correct.
Do you know why these funds were paid to the Fidentia companies? Was there any reason that you could ascertain for those payments?
Well, those payments were made to the from the trust to the Fidentia companies' bank accounts, the accounts listed there.
And why? Did anyone give you a reason why it all went there?
It was done on the instruction of the trustees who assumed the position of trustees when Living Hands Pty Limited was acquired by Fidentia.
Thank you.
So in their capacity as trustees now of the trust, they gave instructions, A, for the money to be called up by Old Mutual, and secondly, gave instructions as to where that money needed to be transferred to.
Now, in paragraph 52, you say that FAM was operated as a Ponzi scheme. Perhaps you can just tell the ladyship what you mean by that.
So essentially what I mean by that, my lady, is that it's similar to a pyramid scheme, but there's where I differentiate the two is that a pyramid scheme requires the individual investor to do a lot more work by introducing new investors so that they can get a return. Whereas the Ponzi scheme, similar in a triangular fashion, but the difference here was that Brown and his cohorts didn't seek to target individual investors and have to deal with a multitude of individuals. They targeted what I'd call pool of investor funds.
Thank you. At paragraph 54, you refer to a forensic report which you prepared at the request of the National Prosecuting Authority in the prosecution of Mr. Brown. And that report appears in bundle 9. Can I ask you now to go to 009-2366? Just so that we're clear, is this document the report that you're referring to in your statement?
That's correct.
Thank you. Can I ask you to explain, and I just want to find the right spot here for a moment. Can I ask you to turn to -2377, which is somewhat deeper into that report. And you see there the main heading status at date of curatorship, and then below that the subheading asset portfolio secured by curatorship order. Can you, in brief, sketch the picture to your ladyship, what you found in terms of where the assets were and what you could locate at that time?
So when we assumed curatorship, the first port of call would have been Fidentia Asset Management to understand in what categories or classes of assets had the investors' money been invested in. And again, it goes back to the inspection report compiled by the FSB. They gave us an indication that there was very little cash invested with Fidentia at the date of curatorship. So it was the objective was to understand what asset classes existed and how liquid these different asset classes were, because that would become fundamental in how we proceeded with the liquidation, considering we had monthly stipends to pay to the beneficiaries of the source funds, which amounted to 9 million per month. So that is why we had to see where we were, if we were going to be able to access cash to pay them.
Please explain to ladyship what each of these items are. They've got labels, but perhaps it's useful for us just to understand what those labels mean. If we look at the table.
Just before he proceeds, I just need you to have a sense of what's going on in my mind. And I leave it up to you. Understanding what happened inside Fidentia is obviously riveting, and it still remains interesting. And I'm wondering, what has it got to do with Old Mutual's liability in this case?
Lady, it is not clear to us on the pleadings that they accept that the monies were dealt with unlawfully and that those actions took place. Lady will know, of course, that we need to show all the elements of a delict, which also deals with the issue of causation. That's one of the aspects. It also turns on the foreseeability aspect of the claim, which is of course also in dispute. So there will be later evidence dealing with the issue of what the plaintiffs say the events were that should have alerted the defendant to difficulties that they ought to report to the relevant oversight bodies. But at the same time, there were consequences that we need to establish that are not clearly admitted. And of course, one must show that the funds were not simply lost in the ordinary course of events, but how they were dealt with. That is set out in the reports. I do not intend to belabor that aspect, of course. That's why I simply want to set out this aspect, and I will then seek to take Mr. Papadakis to one of the annexes to simply give an idea of where the money went. And that will be the extent of what we will deal with in oral evidence, my lady.
All right. I think Mr. Bum has something to say.
My lady, I just want to put the rider in. Of course, that rider was communicated to your ladyship when my learned friend Mr. Epstein had dealt with the way we're going to approach Mr. Papadakis' evidence. In other words, his witness statement stands as evidence in chief. It did say that to speed up the process, the approach we adopt shouldn't be taken as being seen to admit the relevance of everything in the witness statement, and that we will deal with in closing argument. So I just want to put a rider, having heard my learned friend, to his answer to your ladyship's pertinent question, that questions of relevance to the case against Old Mutual is a matter we'll deal with in closing argument.
Thank you, lady. Thank you, lady. We understand that to be the position, yes. Mr. Papadakis, so just to return to what I asked you before the exchanges with the court, in paragraph 6.1.1 at -2377, there's a table, and I wanted you to just identify what you meant and what is the content of those 4 categories of asset classes that you identified there, just in brief, each one.
So the first category is cash, and that represents cash in bank accounts, my lady, which is liquid. The second category was fixed properties that had been acquired utilizing in investors' funds, recorded at cost, and some of the properties were registered in the name of trusts controlled by Mr. Brown. And then the third category would be what's referred to as private equity companies. Those were unlisted private companies. So essentially, that is the assets we had, or that Fidentia possessed at the time we went in.
Thank you. Can I then ask you to turn to Annexure F to your statement? So we're returning to 018. And Annexure F appears at -96. You refer to it in the statement, but perhaps in the interest of time, can you tell her ladyship what Annexure F depicts?
Annexure F essentially seeks to, in an easy to read format, quantify the amount of money invested by living hands and how those monies were applied and how and what has happened in terms of recovery of those assets.
I mean, even with my glasses, I just can't read that. So,
nor can I, my lady, it's very difficult.
If it has
Milady,
to come to attention, it's got to come in a different form.
Yes, Milady, may I suggest we need not detail, unless Mr. Bum has a different view, but we don't need to belabor the detail of this annexure at this stage. And what we'll do is, if Milady will allow, when we prepare that reduced bundle of documents referred to at the end of the evidence, we will ensure that this document is in a format that allows one to properly read it.
It can't even be in A4. It's got to be in a double thing folded so I can see it.
We will ensure that happens. Thank you, Milady. There's another document here, the one just preceding it, which we will do the same with. E at 20, my apologies, 018-95, and we'll do the same with that, Milady. There's also another report, just to, whilst we're on the topic of legibility and user-friendliness, one of the reports that forms an annexure to the statement is a poor copy, because it's a copy of a copy of a copy. Mr. Kunjuzwa's statement, which we will not deal with now specifically, but we will also ensure that that's a legible version in the final bundle. Thank you, Milady.
Thank you. I'll appreciate that. Thank you.
Thank you, Milady. Mr. Papadakis, just back to Annexure F. Do we take it, just for clarification, that the first column, which bears the heading description, gives an indication as to what the monies referred to in the amount column were spent on?
That would be correct.
Thank you. Then, can I ask you to turn to the last part of your statement, basis of the distribution? It commences halfway down -79. But I want to simply take you to the conclusion part of it, the final part of it. So that will be at the bottom of -87, paragraph 91. I simply want to direct your attention to paragraphs 91 and 92. And can you just explain to Ladyship in brief how the numbers work? I mean, we have the summary there, but perhaps it's just useful to just clarify what the numbers are.
Okay. So, my lady, the first figure that's relevant is the 1,133,911,822 rand. Now,
just give me time because my my system hasn't loaded the document. Please just
sure,
give me a minute.
Do we have it, Malay? Oh, not yet. Lady, may I interject with a different issue? I am informed that the transcribers apparently have difficulty hearing Malay. Not sure why that is. Your lady's on mute.
I'm using both screens because that one is not loading. I have no idea why. You can hear me.
I can.
And I don't even think it's a question of diction, so I can't explain why.
Milady, it doesn't seem to be a fatal issue, so I don't think we need to take any steps at this stage.
All right, so I've got the document here in front of me. Can Mr. van der Walt? All right, so you are right.
okay.
Where are we? 018?
-87, Milady.
Right, I've got it in front of me. Thank you.
Okay. So, my lady, the first relevant figure is the 1,133,911,822 rand, and that is the amount of the claim that was submitted by the trustees of Living Hands and accepted by the curators as the claim that the Living Hands Umbrella Trust had against the recoveries made by the curators. From that figure, we deduct the 113,389 million, which was the payments, the distributions we made to the beneficiaries of the Living Hands Umbrella Trust, or to the Living Hands Umbrella Trust, in line and in accordance with paragraph 5.5 of the first court order appointing us curators, which, as I said earlier, allowed us to make distributions to pension beneficiaries.
Yes.
And then following the second order, where we were now permitted to dispose of assets for the purpose of distributing to the beneficiaries, the court approved a distribution plan. Sorry, if the presenter can just go up a bit. In terms of which the 125 million rand was paid to the Living Hands Umbrella Trust, the 125.5 million. That's in terms of the court-approved distribution plan. In addition, another 33.44 million rand was paid directly to one of the source pension funds, and that proceeds from litigation instituted against Lacana, and a recovery of 340,000 from the global funding agreement was paid to the Living Hands Umbrella Trust. So in total, against their claim of 1.1 billion, my lady, the trust, the Living Hands Umbrella Trust, received a distribution of 272.689 million. That would leave a shortfall in their claim of 854.6 million.
Yes.
Milady will note when that number is compared to the claim amount, there is a difference of approximately 7 million. In fact, it's that last amount of 6.5 million referred to in paragraph 92. And at the appropriate time, we will simply seek the judgment for the lesser amount. Thank you, Milady. Mr. Papadakis, one further brief aspect. Do you know how much money Fidentia Holdings had in their bank account at the time when they bought the shares in Living Hands Pty Limited?
Well, there were different bank accounts, but there was not sufficient. There was not sufficient amount cumulatively in all the different bank accounts to effect payment for all the shares in Living Hands Pty Limited.
So where did the funds come from that they paid the shareholders with?
Well, the minority shareholders, what they did is there was some funds left from some of the other investors, and it's detailed in my statement, and Theru, Boltron, and Teta, and that money was essentially used to pay out the minorities for their shares. And I think, if I'm correct, that left an amount of 65 million rand that had to be paid to the two majority shareholders, or the majority shareholder, which was a company styled Pacific Star and Investec. And that 65 million rand was sourced from the first tranche of money, of Living Hands Umbrella Trust money, that Old Mutual released to Maintalia, and which was then Maintalia paid that over to Fidentia, and Fidentia used that money to settle Pacific Star in the order of 65 million rand and Investec in the order of 9 million rand.
Thank you. Milady, will you allow me to just confer with my colleagues before we finalize? Thank you, Malady. Thank you, Malady. We have nothing further.
Thank you.
Thank you, my lady. Good morning, Mr. Papadakis. How are you?
Well, and you, Mr. Bond. Good morning.
Thank you very much. Mr. Papadakis, I'm not even going to say cross-examine you because I'm going to have a discussion with you. I must say at the outset, having gone through your report, it does seem to me that you and your fellow curators, I say curators in the plural because there were two other ones at different times, did quite a sterling job in uncovering what occurred within the Fidentia Group. And I say that in all modesty. It's not the calm before the storm. There's no storm coming up, I can assure you. Mr. Papadakis, you've already testified that the precursor to your involvement in the matter was an FSB report.
That's
and
correct.
That report is the document which commences at page 015-1. You had, I think you had it in front of you a little earlier. May I ask you to go through that? I'm just going to take you through a couple of passages in the report.
Sorry, does the presenter take me to the document or must I find it?
I think in the same way as you had done earlier, I'm not sure how that...
The presenter was taking me to the documents.
Was that from my learned from Mr. Best's side? Perhaps Mr. Best
Yes.
can assist as well, because they had done it earlier. So if I can request them to take you to the document.
Malady, Mr. van der Walt can continue to present.
Of course.
Thank you. Thank you very much, Mr. Best. I really appreciate that. And do let me know once you have it in front of you, Mr. Papadakis.
I don't have it yet.
Malady, may I interject to simply ask Mr. Papadakis to just re-tick the follow presenter button.
Okay, thanks. I've done it.
Thank you. Mr. Papadakis, just going to 0151, you'll see that this was an inspection report of an inspection undertaken pursuant to the Inspection of Financial Institutions Act 80 of 1998. And the inspection report date is 16 January 2007. See that?
That's correct.
It's about 2.5 years after, just a little less, after the money, and I'm going to come to that now, was transferred. The portfolio was liquidated and the money is transferred from, when I say Omut, I'm talking of the defendant, through to FAM, and that's an acronym which has been used, Fidentia Asset Management.
Well, it didn't go directly from the defendant to Fidentia Asset Management. It would have gone first to Mantadia and then Mantadia.
Yes, no, I understand it, but that process of transfer took place about 2.5 years earlier.
That would be November.
So it's October, November. When I say give or take a couple of months, when I say 2.5,
just over 2 years. Just
2 years and 3 months or something of that sort. But the point is, it was as a result of how those funds under the control of Fidentia Asset Management, or so transferred to Fidentia Asset Management, were internally utilized, or may I say misutilized, that the FSB would have felt compelled to investigate what on earth was going on within the Fidentia group.
I think the inspection was premised on a whistleblower.
Yes.
One of the previous directors who approached the FSB.
So in other words, it needed somebody from within to tip the FSB off regarding improprieties occurring within the Fidentia group, which sparked off the inspection.
I don't know if it would have needed that, but that is in fact what happened in this case.
That's in fact what happened. We don't know of anything other than that at the moment, or certainly from your involvement as a curator, you don't know of anything other than that.
No, I only know of the approach by Mr. Rudy Bam to the
Thank you.
FSB.
And of course, one just has to read the report, and without sounding alarmist in any way, I suppose one really doesn't need to sound alarmist when one considers what went on here, that the inspection itself uncovered a bit of a horror show in relation to what happened within the Fidentia group and the conduct of its directors.
Well, it is a horror show, but can I just come back to you saying it needed somebody within to alert the FSB as to what the horror show was. I would not necessarily agree with that entirely, because if you read the inspection report, there were also obligations imposed on the auditors of Fidentia, and they also reported to the FSB that there were potentially material irregularities going on in the affairs. So I wouldn't restrict it to saying somebody within had to come blow the whistle, because there were statutory obligations imposed on independent outside parties, particularly the auditor, who could have alerted.
That's incredibly useful. So you had the assets of inter alia, the trust, which were under the supervision as a portfolio manager, a licensed portfolio manager of FAM, and you had the auditors who themselves were in a position to detect on irregularities and may well have said something about it as well.
They did.
They did. And can I ask you this question? In the you considered, the reports you considered, the investigations that you had considered that had been undertaken prior to your involvement.
Sorry, you froze for a few seconds there.
My apologies. In all of the documents that you had considered in your period as a curator, in the different reports that you had considered, such as the one we've just looked at now, the FSB report, was there any suggestion of the propensity to have undertaken this type of conduct being known prior to Fidentia Group having acquired Living Hands?
What I can say, my lady, they were involved in these unlawful conducts prior and well prior to the Living Hands portfolio being transferred. If you go through the reports I've seen, this conduct started as early as 2002.
My question is a slightly different one. Was any knowledge of that out in the public domain?
Well, I'm not aware. I wasn't aware of anything in the public domain at the time, but it was.
And from what you have seen, from the documents and the extensive investigation you had undertaken, or your consideration of investigations which had been undertaken, was there any suggestion that that was out in the public domain?
Well, I haven't seen any reports, statutory reports. But if I am not mistaken, I think there was a journalist, Bruce Cameron, who had been reporting on Fidentia before or at the time. So, but I'm subject to correction. So that may have been some level of reporting.
We certainly have not seen anything in these papers to suggest that there was any knowledge of this out in the public domain prior to October, November 2004. You can't testify to the contrary, can you?
Not in these papers that I've seen.
Thank you very much. Can I then ask you, and I'm really going to ask you general questions because, as I said, your report really does speak for itself, your witness statement. I'm going to just ask you questions in general terms, and you'll tell me whether you agree that I've captured what you say properly. Now, before we look at the findings you come to and the conclusions you draw, there was a time up until October and November 2004 when the trust's portfolio, at the instance of the trustees represented by living hands, was dealt with by its then portfolio manager, which was Old Mutual. Correct?
Correct.
And you stated already in response to a question on paragraph 53 of your witness statement that on the instructions of those trustees of living hands, that portfolio was moved across to FAM.
Well, those trustees were not the same trustees as that were in place prior to it being moved. It was the Fidentia staff, you can call them staff, directors, officers, that once they became appointed as trustees, they gave the instruction.
No, that's fair enough. But the point I'm simply making is that with Fidentia's acquisition of living hands, new trustees were in place, and those trustees had given the instruction to Old Mutual to move the portfolio across to FAM.
I'd agree with that.
And in this case, on the pleaded case, and there's no dispute about that, FAM was an approved portfolio manager. You don't contest that at the time.
They were an approved financial service provider. So, when you talk about portfolio managers in terms of their license, I think you must just be clear there. There's different categories that you get approved as a financial services provider.
I'm doing nothing other than reading from the particulars of claim, paragraph 34.4. If I just read, you don't have to turn there. FAM was an approved portfolio manager in terms of Section 4 of the Stock Exchange Control Act and Section 5 of the Financial Market Control Act until 1 February 2005. They then applied for license as a financial services provider in terms of Section 8 of FAIS. You're familiar with FAIS?
Exactly, yes.
They were licensed thereafter in 5 November 2004. Now, this is the pleaded case, and I'm sure you would have no difficulty with that.
Portfolio manager up to a point, FSP from a point onwards.
Yes. And when you say up to a point and then something else from another point, it was just because of the change in legislation.
Well, there's a change in legislation, change potentially in license, what you're allowed to do and what you can't do.
Absolutely. And the problem that you uncovered, and your statement is replete with that. You'll find in your statement there are numerous instances where, in bold in your statement, you make the reference that there was fraud, there was theft. So for example, if you go to paragraph 25, the quoted portion in paragraph 25, just after paragraph 25, you'll see references made to the officials of FH would therefore be guilty of theft. This is coming from your reports. You talk about various categories of conduct and you label them as theft or fraud, and they constantly point to directors, officers, and the like of Fidentia, who themselves were controlling living hands. But they were the problem, not so.
Undoubtedly, they were the criminals that perpetrated the crimes, and that is why I presume they, inter alia, Mr. Brown and Mr. Maddock served time in prison.
And so the simple point I'm making to you is that the huge drain out of the trust, or rather from the proceeds of the portfolio of the trust, was as a result of fraudulent conduct within the Fidentia Group.
I would agree with that.
Thank you. Lady, would your ladyship allow me to stand down for no longer than 5 minutes? I just want to confer with my team. In fact, it's now 11:16. Can we take the tea break now and start at 11:30?
Yes, I was going to suggest we adjourn. We will convene at 11:30. Thank
you very much.
Milady, if I may interject there for a moment, my apologies. If you can just give me a second, I just want to check something with Mr. Epstein.
Can we convene?
You want to
Milady, thank you for the indulgence. My apologies. I just want to point out, I'm not sure how much time, not that Mr. Bum knows yet, there for the stand down, how long it will be after tea, but I should just point out that our next witness has just arrived. She won't be settled in until 11:45. So in case that makes a difference to the length of the tea break or Mr. Bum's affairs.
My lady, even whatever my team implores me to do, I'm not going to be longer than 2 minutes after we come back, if as long.
Milady,
I'm quite happy. Let's finish the cross-examination, and if we need to adjourn to settle your witness for 15 minutes, we'll do that.
Thank you, milady.
So shall we adjourn and convene at 11:30?
Thank you, milady.
Mr. Bam, have triggered the reason for the inspection.
Just for me, when was the inspection triggered? What year?
In 2006.
So possibly a couple of months thereafter.
I can give you the dates, lady. I think there was 4 inspection instructions were given. It's in the inspection report. I don't know if the presenter can take me to the inspection report, and I can give you the exact dates that the inspections were triggered. I don't know if Fraser can take me to the, yes, if I can take you to, if you can just go down, please, Fraser, to the introduction part of the report. Go further down, please. If you can go further down, it would be the introduction part to the report. Go down.
I don't think it would be necessary. I'll look at the summary of the report, and I'm sure the dates would be evident there. I just need it to be clear in my mind as we are going along with the evidence.
If I'm not mistaken, it was, sorry, my lady, if I'm not mistaken, it was in the middle of 2006.
Thank you. That's all. Any questions arising from my questions?
Nothing from my side, my lady.
Nothing, thank you, my lady.
Mr. Papadakis, thank you for your assistance. You may be excused.
Thank you, my lady.
Thank you. Mr. Epstein?
Our next witness is Mrs. Atchison. The venue from which she's going to testify is not same venue where Mr. Stamela was. It's not at our chambers. It's in Santon, where
we have lost,
and somebody has now driven her. What's happened? Mrs. Atchison came. Now, so I think we may only be ready by noon. Can we stand down till then?
I don't think she can see or hear you because I can't see you.
I just could not hear what's being said to me, and I'm not sure if Mr. Bam was able to hear you.
I was able to discern the last part, which where I understood my learned friend to ask whether we could stand down till noon, because they're trying to set Mrs. Atchison up. We don't have any difficulties, but of course we're in the court's hand.
Yes, of course, we can adjourn and reconvene at 12 noon.
Thank you, lady. Lady, we've got a technician with Mrs. Atchison at the moment, and we've got him on the cell phone.
Does that mean you need more time?
I see that. I think it looks like we do. I don't know that they haven't got the cameras working. Maybe now. Yes, I see he's in the room now. Should we make sure it's done, milady, and then contact your registrar?
Very well.
I don't know if it's going to take a minute or longer.
Very well. I'm sure Mr. Brown won't object, so we'll give you more time to get organized.
Thank you.
We'll
Already,
contact
I'm
your
waiting
registrar.
on my computer. So when I see my learned friend's face again, I'll know we're ready. Thank you.
Yes, thank you.
Thank you. Listen, before we can't get the technical company can't get the overhead camera to work. The position is that they can't get the overhead camera to show the whole room to work. There is a candidate attorney with Mrs. Atchison. Can I ask him to confirm to you that he's the only one in the room with her and that he's going to leave? Will that satisfy you?
That would satisfy me, Mr. Bum.
We don't even need the confirmation. If that's what my learned friend says to me is the situation, he can place it on record and we're fine with that.
I don't know myself, so I'd have to ask him. Mr. Gumans. Okay. Can you unmute, please?
Hi, can you hear me?
Mr. Gumans? Yes. Could
Yes.
you just come on camera, please?
Sure, yes.
Your name is Michael Gumans?
Yes, my name is Michael Gumans, and I'm a Canada attorney at Knowles and Lindsay Attorneys, and I can confirm there's no one else in the room.
Only you and Mrs. Atchison?
Yes, only myself.
Okay. Could I ask you to leave the room, and if it's stay in the vicinity in case there's a problem, we can call you back.
Sure, no problem. Thank you.
Thank you.
Sure.
Then we're calling Mrs. Atchison, Mrs. Ivanka Atchison, our next witness.
Yes. Mrs. Atchison, will you spell your name for the record?
First name, Ivanka, and my surname, Atcheson.
Do you have an objection in taking the prescribed oath?
I don't.
Will you swear that the evidence you're about to give is the truth, nothing but the truth? Lift up your right hand and state, "So help me God."
So help me God.
Your witness.
Thank you, lady. Mrs. Atchison, you were previously employed by Ltd Asset Trust Company, which we know is known as MATCO, correct?
Correct.
From when were you employed?
It goes way back to the early 90s when the company was called CFM. Then it was taken over by Mercantile Bank in the later 90s. And then in 2001 was purchased by Ltd. So I've been with...
Sorry, go ahead.
I've been with I was with the company from the early 90s.
Yes. And as the business was sold, you moved with the businesses which were then owned by the separate companies, correct?
That's right.
Now, what you initially employed let me lead you on this. You initially employed as a telesalesperson?
That's right.
And then you worked your way up to become manager?
Correct.
Now, as a manager, what could you explain to the ladyship, what were your functions, who were you in charge of?
We had an administration staff of, depending on the time, between 30 and 40 people, and we were processing payments to beneficiaries and guardians from the trust that we were managing. So it was a paper-intensive business.
You ultimately became a director and a shareholder of MATCO.
That's right.
And when the shares in MATCO were sold to Fidentia Holdings, you were one of the sellers. Your shares were sold together with all the others, and you were paid your pro rata purchase price.
That's right.
And when the business was sold in 2004, October 2004, did you continue to stay with the Fidentia, with the new owners, or did you leave?
I was there for approximately a week. The intention was to leave. My resignation was in place, but as a handover process, I stayed for approximately a week, which was less than the resignation period.
Yes. When you resigned, you made your resignation effective from 30 November 2004, but you left before that.
That's right.
Now, let me take you to the deed of trust, which is at 00160. It's POC 1, the lady. And if you can follow that, Mrs. Atchison, it's been put be able to follow it. It? Mrs. Atchison, do you see?
I see a document 0011.
Can you see at the top there, can you select follow presenter?
Select presenter.
Select presenter.
Then select follow presenter.
And then follow presenter. And then you'll see Van der Walt. You got it, right. So that, you see that is it. Yes. You see, that is a deed of trust between Consolidated Fund Managers and CFM Trustees, P2R Limited. And at page 00163, it was the trust, which is CFM Trust. Correct?
Yes.
You see that?
I do.
And then that trust became known as the Matco Trust.
Correct.
Okay, go to page 00166. You'll see at paragraph 4, there's the object of the trust.
Yes.
And at paragraph 4.2, it says, in order to avoid a proliferation of trusts, which would arise if a separate trust were created to administer the funds of each beneficiary, the settlers establishing the trust, but on the basis that the amount to be administered or held on behalf of each beneficiary shall constitute a separate trust fund, being the beneficiary trust fund. The trust fund of each beneficiary shall be maintained as a separate fund in the books and records of the trust. Now, were you aware of this trust deed when you were working at Matco?
Yes.
Now, can you explain to Milady the what the functions were of Matco with regard to the deed of trust?
Okay, the deed of trust, we received an amount in respect of a death benefit from a pension or provident fund. They had done all the investigation. We received the amount, and it was to be allocated to the deceased's children or dependents, and it could be any dependent. And we then created a separate trust for each beneficiary, the beneficiary meaning a child, generally underage beneficiary, dependent on the deceased. And we created a separate trust for each of those beneficiaries, and we, with separate amounts allocated to each of them. The amounts varied according to the ages. So if there was an 18-year-old, obviously, or 17-year-old would need less funds to finish schooling as opposed to a 1-year-old. So the amounts were allocated by the pension fund for each child, and we managed those individually on the system under this umbrella fund.
Okay, let's go slowly. So money comes in from a provident fund, and
Yes.
are instructions given from the fund as to how you should allocate the monies to the various beneficiaries.
Correct. Which amounts or percentages, as it may be.
Did Matco have a discretion as to how to allocate monies to beneficiaries?
No, the instruction usually came from the provident or the pension fund.
And the amounts paid each month, were they the same amounts or did they vary?
It was based on the amount in the actual trust held for that beneficiary. If it was, for instance, an amount of 2,000 Rand in that particular trust, then the income of that trust would be, for that month, would be paid to the guardian.
Now, does the money, when you say it goes to the guardian, the money is paid to the guardian, and that's the guardian of whom? Of children?
The guardian of the children, which could be anyone. It could be a mother, a brother, a sister, an aunt, whoever was taking care of those children. The income from the amount allocated for that particular child monthly would be paid to that guardian. Not in all cases, but in most cases.
Because obviously the beneficiaries were minors.
The beneficiaries were minors, and they needed their needs met for basic monthly needs, for food and clothing, whatever the case may be. That monthly income was to provide for those beneficiaries, to give the guardian the funds to look after those beneficiaries.
Now, how many beneficiaries were there? Let's say at October 2004. Can you estimate how many beneficiaries there were?
I would say in the region of about 50,000 odd beneficiaries. So that's individual records for beneficiaries, yes.
And how many of those were children?
They were all children. There were 99% were minors. There could be very few cases where it was a person over majority, but that would be because they were incapacitated in some way, which could mean disabled or mentally not able to take care of their own funds. So they would still have somebody looking after them. But the majority of them were under 18.
And it terminated at age 18?
In most cases, there were, once again, very few that terminated at age 21 or 25, but those were rare and few and far between. And those were determined by the actual trust, by the Pension Provident Fund.
Did you interact with any of the beneficiaries in person?
Not the beneficiaries normally, it would be the guardians that I interacted with. On the odd occasion, a beneficiary, but because they were minor, the interactions were between myself and the guardian.
And what kind of interaction would you have with the guardians?
It would be basically queries that they would phone in. How would they get a uniform for their children? How would school fees be paid? When will the payment be made? How will the payment be made? And then they would send me the document, well, me, I'm talking my department, the documentation with an invoice or a receipt that needs to be either paid directly to the supplier or to be refunded because they had already paid it.
Now, we know that the monies from the Provident Funds, which were received by Matco, were placed in investments with Old Mutual unit trusts.
Correct.
From each month, when you made payments to the guardians for the beneficiaries, from what source did you make those payments?
We had a certain amount available, especially at that time, at the end of the month, that we could do a credit payment run, and that was liquid. That was in Investec on a call account that we earned interest, that the money is earned interest on. So that money was drawn from an Investec call account, money market account, whatever the case may be at the time. It wasn't. It was realized during the last week of the month, or we had it in cash that it hadn't been invested yet through Old Mutual. There was always a certain amount of cash.
So you kept the floats basically to pay that.
Correct.
Now, who was Symmetry Asset Management?
Symmetry was Old Mutual, the asset management company where the Old Mutual funds were, where the funds were invested in Old Mutual.
Did you deal with anyone at Symmetry?
The only person at Symmetry that I know is Kevin French, that I can recall. There were others. I don't recall their names.
And what about Old Mutual? Did you interact with anyone at Old Mutual?
We interacted with the staff, not myself personally, really. My staff dealt with their staff to realize for units to be sold, to realize the cash as a withdrawal or to invest, but mainly the dealings were from staff to their staff, and it was system driven.
Can you go to 00186? Is it there, Fraser? So you'll see that that is a service level agreement.
Yes.
It's actually in the year 2000. It's between Mercantile Asset Trust Company. You explained that you originally employed there before the businesses were sold. And it's between Mercantile Asset Trust Company and Mine Workers Provident Fund. And over the page at 87, it says, whereas the fund is required in terms of the Pension Funds Act and the rules of the fund to pay death benefits arising from the death of members of the fund, and whereas the fund from time to time requires the said death benefits to be paid into trust for the benefit of dependents and nominees of the deceased fund member, and whereas the administrators agreed to establish and manage the envisaged trusts. And over the page at 88, paragraph 3 talks about settlements. It says a settlement paid by the fund to the trust shall be accompanied by written instructions from the fund to the trust. That's what I think you testified about earlier, that you get instructions from the fund. Is that correct?
Correct.
Yes. And then it says, so the settlement is accompanied by written instructions from the fund to the trust, specifying the full names, ID numbers, address and bank account details of the beneficiaries of the settlement, and details in respect of any guardian of the said beneficiaries. And is this document you see here, is this typical of the type of service level agreement?
I think,
Sorry, can you hear me?
There is an interruption coming through from your side. I'm not sure whether it's the broad parent. Your image flickers and there's a bit of background noise or your voice drags. Is that what you're also hearing?
Yes.
Yes. I think something is happening on your side.
Got all the devices off.
Yeah. If we continue in that fashion, it is also going to interfere with the recording. That's my concern.
Let us do it by process of elimination. And those who are watching on their screens, just switch everything off. Can we just try that? Still. Are you off? Everything, Andy? Everything's okay. Is it any better now?
For now, yes.
Okay, let me carry on and hope there's no further interruption. Mrs. Atchison, what I was asking you is, with regard to the service level agreement, is this typical of the service level agreements which you would have with provident funds?
Yes.
Then if you go to 00194, that's POC 4, that is an agreement between Omid and Mantalia, which is Matco. And at the 95, it says the client is a trust administration company. The Manco is a management company. It is the purpose of this agreement to set up the terms and conditions under which the client will buy, sell, and switch units in the unit trust funds administered by Manco through bulk accounts with the Manco, and to further regulate the relationship between them. Did you have any involvement in giving instructions to Old Mutual to effect switches from time to time?
Yes.
And please tell Her Ladyship what involvement you did have.
It was when beneficiaries were coming of age, we had to sell their holdings, and it was normally done. It started before so that we could get the best possible prices. So it was a process. And then the units were sold. There was an instruction to Old Mutual to sell those units to realize the investments, and then they would make the payment to the trust account, upon which, on the date of the termination, we would pay the beneficiary. And also, on the other hand, when we receive funds, we would send an instruction to Old Mutual to say, this is how much money is for this particular bid. It was done in bulk, but that would be, they didn't have a record of each individual beneficiary. We kept that, but the monies were placed in bulk.
Now, I want to take you to a few documents and ask you to comment on them.
Okay.
I want to start at 0091. Mrs. Atchison, you'll see this is a document which the front cover, which is diligence, care, skill. It's got Old Mutual employee benefits, and then it's got Matco underneath it. Now,
Yes.
at 0093, it says introduction to Matco, and it's got a history of Matco. And further down, it's got about Hardy Milan, who was one of the people at Matco. Then it's got yourself, Ivanka Atchison, saying that you started your career at CFM Management in 1990. You've been involved in portfolio and trust administration from the beginning, and it gives some blurb about you. And then Gova. Now, do you recall this document at all and what its origin is?
No, I don't, unfortunately.
Now, at page 14, it says they Ltd Asset Trust Company, and then the fourth paragraph says Matco is extremely good at caring for the minor dependents, safeguarding beneficiary funds, providing monthly income for basic needs, investigating and making the payments each year for tens of thousands of school fees, school uniforms, books, etc. Is that an accurate statement of what Matco did?
Yes. That is exactly what we did.
Yes. But you can't, I mean, it's a long time back, and talking about 2002. You don't recall what the
no, I don't.
what the document was, why it was produced.
No, I don't.
And whether it was produced by Matco and Old Mutual or both of them together, that you can't recall. Okay.
I don't.
Then we go to 009103. It says in the second, let's just see what this document is. Let's identify it first. At 0096, it says investment proposal, Ltd Trust Company, P2R Limited in March 2002. And it says presented by Symmetry Multi-Manager at 96. Then if you go to 103, it says under the Galaxy Funds, the second paragraph, Old Mutual Unit Trust Managers Limited is the management company, and Symmetry Multi-Manager Portfolios designed and manages these tailor-made portfolios. Symmetry seeks to select and appoint the best asset management houses to act as investment managers for specific investment mandates. Symmetry, through research, multi-manager process and innovative product design, creates a unique construction of multi-manager unit trusts with potential to achieve enhanced investments, performance within acceptable levels of risk. So the first thing I want to ask you is, do you recall this document?
I don't recall the document exactly, but Galaxy was the plan created by Symmetry, tailor-made for MAPCO's funds.
And you've already said that you did engage with Symmetry. If we go to 009152, that these are minutes of the meeting of Investment Subcommittee of the Board of Directors held in May 2002. And we see present there with Guthrie and yourself, Discover Milam. You were all directors. And in attendance was J. Peterson of Old Mutual. Firstly, do you remember Mr. Jos Peterson?
I don't.
And
it's likely that I met him, but I don't.
It says at 3, Old Mutual, Jos Peterson of Old Mutual made a presentation to the committee regarding the recent appointment of Old Mutual as asset managers, detailing the transition and processes which followed.
Pardon me, this monitor keeps turning off. Okay. I'm back.
See paragraph 3. It records a presentation made by Jos Peterson of Old Mutual.
Yes.
The point is that, just if you could comment, it seems clear that you had interactions, meetings with Old Mutual. They came to meetings of your directors, correct?
Correct.
And did you ever visit Old Mutual?
We did.
For what purpose?
Just to introduce ourselves to the staff and to have a relationship going, meet with Kevin French and just have interaction with them because they were managing our funds and just to keep the relationship going.
So was Old Mutual familiar or intimately, did they have intimate knowledge of the business that you did and who the beneficiaries were?
Yes, they did.
Can you go to 009709?
Sorry, I missed that reference. My apologies.
009709. Now, this is after the sale of the shares to Fidentia. It's dated 22 October 2004. You've been paid your purchase price now for your shares, and it's a letter written to Arthur Brown by Mr. Raymond Barelowitz from Old Mutual. I'm going to come in a while to your involvement with the sale to Fidentia, but this is just after the sale takes place, and you'll see that written by Mr. Raymond Barelowitz, and underneath it says, good afternoon, here with his documentation from Raymond Barelowitz. It's from his PA, his personal assistant, to Raymond Barelowitz and Kevin French of Old Mutual Symmetry Multi-Manager. Did you know Mr. Raymond Barelowitz?
Not that I can remember now.
But Kevin French you knew?
Yes.
Okay. Now, I just want you to comment on what is stated here insofar as you have knowledge of this. It says, attention Arthur Brown, from Symmetry Multi-Manager. This document serves to provide clarity around the relationship between Old Mutual via Symmetry Multi-Manager and Old Mutual Unit Trusts and MATCO, along with an initial proposal for an ongoing relationship with Old Mutual. Then under number one below that, under where the bold type is, roles, responsibilities, and legal standing for each party. MATCO as client, acting on the advice of Symmetry Multi-Manager, invests a range of collective investment schemes with Old Mutual unit trusts. That's something you are aware of. You've testified about that, correct?
Yes.
Right. Then it says Symmetry is a business unit within the Old Mutual Life Insurance Company of South Africa, OMLACSA. As such, it operates under OMLACSA's phase license, pre-30 September 04, OMLACS Asset Manager license. Symmetry specializes in the creation of products for institutional clients. These products blend asset managers to meet the needs of its clients. And you've testified about the Galaxy product, which was for Matka.
Correct.
Correct. And then they say Symmetry has historically provided two primary functions to trustees. Firstly, as investment advisors, and then they say what it includes, and secondly, as multi-manager via OMIT. Further down on page 711, it says,
Mr. Epstein, do you want the witness, just 1 minute, do you want the witness to confirm that? Because I'm not sure whether, yes, because she wants to answer, but you moved along too quickly.
Mrs. Atchison, they say Symmetry has historically provided two primary functions to trustees. First is investment advisors, and secondly as multi-manager via OMIT. Is that how you understood their role?
I do, yes.
And then there are about 5 bullet points below that, and then it says, and we're now on page 711, OMIT is a wholly owned subsidiary of OMLACSA, operating under the Collective Investment Schemes Control Act. OMIT, on the advice of Symmetry regarding mandate formulation and manager selection, invests the CIS in portfolios with a number of external managers. OMIT is accountable to the FSB for the funds, specifically as regards portfolio compliance, fund accounting, pricing, valuation, and administration of transactions.
Correct.
Did you know that they're a wholly owned subsidiary?
Yes.
Then, for our purposes, clearly what Mr. Barelowitz was trying to do here was to retain the business of Matco after it had been acquired by Fidentia. And you'll see that at paragraph 3 on page 713 at the bottom, he says to Mr. Brown, partnership with Old Mutual, a very close relationship with Matco. The cornerstone of this relationship has been that we understood how important it was to provide the beneficiaries of the thousands of trusts in Matco's care with appropriate investment performance. You've confirmed, and you can ask you to confirm again, that Old Mutual did have this very close relationship with Matco.
Correct.
Correct. And that they knew who the beneficiaries were. You've already told.
You're breaking up.
That, and at end conclusion. Sorry, do you hear me now?
I can hear you now.
You broke up, Mr. Epstein, and the witness was trying to alert you to that.
Thank you. Mr. Atchison, we've dealt with paragraph 3, and you've confirmed there a close relationship and that they knew who the beneficiaries were.
Correct.
Correct. And paragraph 4 is a conclusion which says, I hope that this document has allayed some of the concerns you have had, that the proposal on the way forward finds favor with you. If this is the case, we'd be pleased to engage in more detailed discussions on how to progress the relationship. Now, you said you stayed on for not for too long, maybe a week or so.
Yes.
From the time that you stayed on after you'd sold your shares, do you recall whether whether Matco had any further dealings with Old Mutual from that time onwards?
No, I wasn't involved in any. That is the reason why I left as well. There was nothing. I wasn't involved in any management, in any dealings with anyone.
Did you meet Mr. Brown, Arthur Brown?
Briefly. in a meeting.
At which stage? Do you recall? Before or after the sale?
Before. Possibly after that, I saw him in the office as well, but I didn't have meetings with him after.
Okay. Were you involved in the negotiation of the sale of shares to Fidentia Holdings?
Not involved in a negotiation per se, no.
Just bear with me for a moment. Sorry, my lady, if I could just have a moment. I don't know why.
Very well.
Yes, the sale of shares agreement, you needn't go there. We know that there was a sale. We know it was signed by all the shareholders, including you. Who negotiated the sale?
It would be with Hardy Marlam and Jeff Gover. Together with the two guys from Investec.
They were representatives. I don't think they were directors, but
no.
Do you remember their name?
Colin Franks and I don't recall the other person's name. So
go ahead.
I do have a bit of an issue with my memory from an incident that happened a few years ago, but I'm trying my best to recall.
Don't worry, you don't have to remember everybody's name. Don't worry. It's many years back. We mentioned Colin Franks, and did you? To what extent were you reliant on what Investec was advising concerning the sale of the shares?
To a large extent, this was not the first time they negotiated sales. They were with us from the beginning. They had our respect and they had a good reputation in the industry. So I did rely on them to a great extent.
Did you scrutinize this agreement before signing it?
I looked at it. I was guided by pretty much Investec, their involvement in it. It was an admin-intensive business, so I did rely on the people from Investec quite a lot. That wasn't my area of expertise.
Now, you'll remember that in October 2004, all of this took place when you resigned as a director and transferred your shares. Do you know when Fidentia became the shareholder in Matco?
No, not exactly. I don't.
I just want to take you to .009 663. Do you see that?
Yes.
It's a letter dated 18 October 2004. It's on a Matco letterhead. And at this stage, although it's cut over the bottom, you can see the directors were Baloy and yourself, Atchison, and Ditz and Gibbs. So you were the existing shareholders, directors. And it says, "Dear sirs, I hereby tender my resignation as the director of the company with effect from 12 hours on Tuesday, 19 October 2004. I hereby further tender my resignation as an employee of the company with effect from 30 November 2004. And if you go to the very next page, 664, there is a letter of resignation from Danisa Baloy, who was also director, also on 18 October, also to resign the next day at 12 noon on 19 October. Now, do you know why it was done this way? What was to happen on the next day, 19 October?
The sale of the shares would have happened and payment of those shares would have had to reflect in our account before the resignation came through as a shareholder.
Do you know whether the money you received, your pro rata amount, was paid to you before your resignation took effect? In other words, you know if it was paid before 12 noon on Tuesday, 19 October?
As far as I recall, it was John T. Gibbs and Jeff Grover came to me and asked me to check my bank account and see that the funds were in, and I recall checking it and they were in.
Now, so far as Fidentia is concerned, that is Fidentia Holdings who purchased the shares. Did you know about them? Had you heard of them? Did you know of them in the marketplace, so to speak, or in the industry?
No, I didn't really know about them, but I didn't know about a lot of the other players either in the market. So no.
You hadn't heard of them before this?
No.
And Mr. Brown, you say you met him. Did you meet him shortly before the sale?
Possibly a month or two before, I think. I can't say with exact certainty. I know he came into the office once, and but not really a meeting, just an introduction, basically.
Lady, might just have a moment to go on mute just to find out from the team if there are other questions.
Yes, you may.
Okay. Yes, this is Atchison. One final thing. Do you know when NATCO was doing the administration and all the funds were with Old Mutual, do you know in what investments the funds were kept by the defendant?
Which specific investments?
Yes.
Or what type of investment? They were in unit trusts.
Well, they were in collective investment schemes, those. Did you know that?
I'm not sure what you mean. It was basically a bulk investment in different unit trusts managed by Old Mutual, placed by Symmetry.
Yeah.
Overseen by Symmetry, correct, yes.
Thank you, lady. I have no further questions for Mrs. Atchison.
Thank you. I think it's going to be appropriate. And let me hear from you, Mr. Azar.
I may well be finished before lunch, my lady, and if I spill over, it may be for 5 minutes. So if you'd like me to finish off now, I'm happy to do so. If you'd want me to pick it up after lunch, I have no difficulty with it either. I'm entirely in your ladyship's hands.
I think that it might serve us well to see if we can complete with the witness now. Just to alert you, I have a memorial service of Judge Manama to attend, scheduled for lunchtime. but I'm prepared to be late if you believe you are not going to take long.
My lady, I will finish by lunchtime. Thank you. Good afternoon, Ms. Atchison. How are you?
Good, and you?
Thank you. Ms. Atchison, you can be certain about one thing. I'm not going to test your memory, so don't be too anxious about that at all. Ms. Atchison, as I understand it, you were a shareholder in Metco, which is now Living Hands. Am I right?
Correct.
And you had quite an involvement in the company for quite a while, a long period of time.
That's right.
Is it 2002?
Correct.
You were also aware of the function it performed in relation to the trust, who the beneficiaries were, and you would have been quite anxious to ensure that their interests were protected, not so.
Correct.
And at some point, you sold your shares to the Fidentia Group. I'm just going to refer to it colloquially. But you weren't alone in doing so. Everybody sold their shares. And as I understand it, that sale, the negotiation leading to that sale, was primarily handled by Investec. You mentioned the name Colin Franks. And if I understood you correctly, you quite trusted them. You had no reason to believe that if there was anything that they ought to have brought to your attention, they wouldn't do so.
That's right.
And presumably, for purposes of negotiating the sale of shares, which would have put the Fidentia Group in control of Living Hands, as it then became, Metco at the time, Investec itself would have been aware of the function that Metco had performed, the type of beneficiaries whose interests they were taking care of, and all of those types of things, correct?
That's right, they were.
And I would imagine that at the time that the sale of shares was concluded and you and your fellow shareholders had sold to Fidentia, which included personalities such as Mr. Brown, there was nothing communicated to any of you by Investec, your trusted negotiator, to suggest to you that the purchasers you were selling to were, I'm going to use a colloquial phrase if I might, were dodgy characters or potentially dodgy characters. I can't say it better, but you'll excuse my colloquialism.
That's fine. There was nothing to indicate that. No feedback that I heard.
And would I be correct, and would it be fair to you, and presumably you had a sense of who your shareholders were, would it be fair to you to say that if they had indicated to you that you were dealing with less than savory characters, given your concern for the beneficiaries, you would have had major doubts about proceeding with the sale?
That's right.
Thank you. That's very fair, and I would have imagined, I expected the approach you've taken to be your approach, because you strike me as somebody who did care about the beneficiaries. Ms. Atchison, thank you very much. My lady, I promised 10 minutes. I came in under that. I know there's a fine for bad quality Wi-Fi. Do we get a credit for coming within our time, my lady? I have no further questions.
I'm not so sure about the credit yet. It will be judged at the end of it when we square the books.
Does that depend on the quality of the trustees, my lady?
It will have to depend on the quality of the.
My lady, I have no further questions. Ms. Atchison, thank you for your time from my perspective.
I don't have any questions for you either. Any re-examination?
No, I don't have any, my lady.
I beg your pardon. I beg your pardon. Yes.
No, I don't have any re-examination.
Yes. Thank you. You may be excused. Thank you.
Thank you very much.
And what is
My
the
lady,
order?
will you recall, my lady, that we don't have another witness today. He's flying up from Cape Town. So can we start tomorrow morning at 10?
Yes.
And we'll do our best to make sure that the room where Mrs. Atchison, we'll do our best to make sure that the room where Mrs. Atchison is has been dealt with efficiently by the technical people.
And your own device as well. I think they need to look at it.
If you're referring to my device, my lady, you know the famous thing which advocates say when they've got a problem, they say, I didn't draw the pleadings. Well, I can say this isn't my device. It's somebody else's.
I see that.
My lady, may I inquire through you of my learned friend what his remaining sequence of witnesses is?
It's Mr. De Jong, it's Mr. Malan, and then Mr. Anderson.
I'm most grateful.
Thank you.
And of course, we can give Mr. Anderson's statement and they can decide if they want to consider it in the same ways they did Mr. Papadakis.
You can be certain that if you do give us that, we will consider it in the same way. Thank you very much. In fact, if you want to give us any of the witness statements, we'll consider it in exactly the same.
I think that would be helpful.
We don't
I
have,
thought he
but
had
we have
given us a list of witnesses earlier this morning, but be that as it may, that's the order of the day from tomorrow. Are they available to testify one after the other?
Yes, they are.
Thank you.
Mr. Anderson, I'm sorry, my lady. Mr. Anderson is in Italy and we'll have to set him up.
Yes.
So I don't know what the logistical, it'll probably only be on Thursday for Mr. Anderson.
Yes.
That's fine from our perspective. May I, through you, I know I alluded to it just now, but with Mr. Anderson, as with the other two witnesses, if my learned friends do have witness statements, A, it would assist immensely, and B, it would speed up how we're moving in the case. I'm just throwing it out there, Matthew.
Okay, well, and we don't have of the other two, we only have of Mr. Anderson. But we will share that. Thank you.
Much appreciated. Thank you.
Yes, thank you. Can I just inquire, you were going to transcribe the record overnight. Was that achieved?
We got a copy of yesterday, my lady.
I would appreciate if the record is loaded on case lines for me as well.
We'll do it in 019.
We'll do that at 019.
Created.
We'll create 019.
Yes, I'd appreciate that. Thank you. That being the case, we adjourn until 10 tomorrow morning.
Thank you.
Thank you.
Thank you.
Please excuse me.